Let's continue the discussion of nature and effects of obligations with liabilities. Excerpts are taken from the Law on Obligations and Contracts by De Leon. This is CE Laws, Contracts, and Ethics. Starting with Article 1170, which states, those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. The above provision gives the four grounds for liability, which may entitle the injured party to damages. First is fraud, deceit, or dolo. It is the deliberate or intentional evasion of the normal fulfillment of an obligation. Let's take an example. An engineer ordered grade 60 reinforcing bars from a supplier, but what was delivered was grade 40. The supplier is guilty of fraud and is liable for damages to the engineer. Second is negligence, fault, or culpa. It is any voluntary act or omission, there being no bad faith or malice, which prevents the normal fulfillment of an obligation. For example, it is one of the responsibilities of the site engineer to ensure that the construction materials for a project are secured and they should be kept in their optimal quality. It is one requirement that such materials are suspended from the ground to avoid moisture and to avoid corrosion of rebars or even hardening of the cement. The failure to do his duties constitutes negligence. Third is delay, which has already been discussed previously. And lastly, contravention of the terms of the obligation. This is the violation of the terms and conditions stipulated in the obligation. Not following the terms stipulated in the contract of which both parties agreed can be considered as contravention of the terms of obligation. Fraud may be distinguished from negligence as follows. First, in fraud, there is deliberate intention to cause damage or injury, while in negligence, there is no such intention. Waiver of the liability for future fraud is void, while such waiver may, in a certain sense, be allowed in negligence. Third, fraud must be clearly proven, while negligence is presumed from the violation of a contractual obligation. And lastly, liability for fraud cannot be mitigated or reduced by the courts, while liability for negligence may be reduced according to the circumstances. Article 1171 states that responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. According to time of commission, fraud may be past or future. A waiver of an action for future fraud is void, no effect as if there is no waiver, as being against the law and public policy. A contrary rule would encourage the perpetration of fraud because the obliger knows that even if he should commit fraud, he would be not liable for it, thus making the obligation illusory. A past fraud can be the subject of a valid waiver because the waiver can be considered as an act of generosity and magnanimity on the part of the party who is the victim of the fraud. In the next article, Article 1172, it says responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. In the performance of every kind of obligation, the debtor is also liable for damages resulting from his negligence. There are different kinds of negligence according to source of obligation. First, we have contractual negligence or culpa contractual. This is the negligence in contracts resulting in their breach. This kind of negligence is not a source of obligation. It merely makes the debtor liable for damages in view of his negligence in the fulfillment of a pre-existing obligation. Second is civil negligence or culpa aquiliana, or negligence which by itself is the source of an obligation between the parties not so related before by any pre-existing contract. It is also called tort or quasi-delict. The third and last kind is criminal negligence or culpa criminal, or negligence resulting in the commission of a crime. The same negligent act causing damages may produce civil liability arising from a crime or create an action for quasi-delict under the Civil Code. Article 1173 details fault. It says that the fault or negligence of the obliger consists in the commission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and of the place. When negligence shows bad faith, the provisions of articles shall apply. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. What is fault or negligence? Fault or negligence is defined by the above provision. According to our Supreme Court, negligence is the failure to observe for the protection of the interests of another person that degree of care, precaution, and vigilance which the circumstances justly demand, whereby such other person suffers injury. Negligence is a question of fact, that is, its existence being dependent upon the particular circumstances of each case. In determining the issue of negligence, the following factors must be considered. First, nature of the obligation. For example, smoking while carrying materials known to be inflammable constitutes negligence. Another factor is circumstances of the person. For example, a guard, a man in the prime of his life, robust and healthy, sleeping while on duty is guilty of negligence. The third factor is circumstances of time. For example, driving a car without headlights at night is gross negligence, but it does not, by itself, constitute negligence when driving during the day. The fourth and the last factor is the circumstances of the place. Driving at 100 kilometers per hour on the superhighway is permissible, but driving at the same rate in a community street is gross recklessness.